ಅದಕ್ಕೆ ಮುಂಚೆ ನಿಮ್ಮ ಫೋನ್ ನಂಬರ್ ಲೈವ್ ಇದೆ ಅದರ ಏರಿ ಇಲ್ಲ ಬೇರೆ
I was arguing not where the brief notes last seniority prepared was certified by anything a judge in the year 2012 in division bench. Synopsis, relevant facts, not brief note with synopsis. I explained to your lordship on later decision Supreme Court also. 4-point roster system, how it, I was reading that 1911-2025 judgment, where it has no application. The fact, because Supreme Court declared the law on 1911-25, 4-point roster shall be adopted by High Court, all High Courts, they must frame the rules, I mean, in consultation with the not respective department. But Supreme Court said it has no application for this case, not future purpose. Therefore, my lord has to adjudicate now the question raised in this, not the reference, in this reference. My lord has to examine the divergent view taken by the lord division bench, which view is correct. Our main contention in the writ petition is only two. Quota is not maintained. As per the recruitment rule amended from time to time. The second question is not the fast track judges who are appointed in the year 2003, substantially promoted in 2009, are entitled promotion from the date of earlier to that date. If there is no substantial order of promotion, probably right. Though they are appointed as fast track in 2003, 2009 not substantive promotion order was issued. But in the view of the latest Supreme Court debate, law legislated, fast track judges are concerned, they are not entitled to seniority, but however, full protection of pay and pension is given. That service, ad hoc service also shall be counted for the purpose of pensionary benefit. Pensionary benefit, nothing else. Therefore, nobody, fast track who have retired, are not excluded because their pay and pension, everything is protected, except seniority. I was explaining the principle laid in in case of Ashok Kumar case, where Supreme Court examined the rule as it was in Tamil Nadu Judicial Service. There was no quota fixed under the rules. It has referred particularly that paragraph and where there is a Lord, promotion of 1/3, quota will operate. That is what the Supreme Court says. Page 10 of my Lord, brief notes, Lord. Lord, quota provided under the recruitment, different source recruitment to the post district judge from time to time shall be maintained. Shall be maintained. I also, my Lord, pointed out your Lordship, my Lord, the Shambulingappa's case, my Lord. The particularly refers that full court resolved to, my Lord, fix the 1/3 quota from 11/3/87, Lord. That is referred in para 9 of the judgment of Shambulingappa's case, which I have already pointed out to your Lordship. Which is, my Lord, page 12 of my brief notes, my Lord will find, referring to page 11, Lord. I will not again, Lord, re-argue the Ashok Kumar case, which I have already argued, Lord. I do not want to take precious time this court. Then 12, my Lord, is Shambulingappa's case. But I called out the particular paragraph. Then, my Lord, I pointed out to your Lordship, divisional bench of this court, in para 60 of the judgment, in 2014 held, my Lord, quota will operate from 27/83, 24/8/1983, on which date rule is promulgated. 2/3 promoting, 1/3 not direct equities up to 8/9/2005. 8/9/2005. 8/9. My Lord will find the referring to All India Judges case, my Lord, in 2002, 4 SCC 247, my Lord, I have already explained to your Lordship, my Lord, why the recruitment rules in the year, Lord, 2011, 11/9/2011 came into effect on 1/11/2011, because Supreme Court has declared the law. If the High Court will not promulgate the law within a period of, Lord, 31/3, my Lord, 2011, it will come into effect from 1/11/2011. Therefore, our High Court, while DPR promulgating the rule, fix the operation of quota with effect from 1/11/2011. But I have already produced the rule, Lord, in the list of enactment, and that is, Lord, 1/11/2011. Only change of quota is, Lord, promotee is concerned 65%, Lord. 10% is by promotion through limited competitive examination, Lord. 25%, Lord, is the for DR. DR. Prior to that, my Lord, only 1/3, that 33 1/3. Then, my Lord, 1/1/2011 to 19/5/25, Lord, quota is, Lord, again, that 1/9/2005 to 31/12/2010, Lord, quota is 50% by promotion, 25% direct equipment, 25% limited competitive examination. Then, my Lord, 1/1/2011, my Lord will find quota is changed. That is 25 direct equity, 65 by promotion, and 10% by limited competitive examination. 25 2025, again quota is restored. Again, not 50, 25, 25. I have produced the judgment also. Supreme Court has initiated the law. Though we have not concerned, I have just not bring your lordship notice that what is the law from 83 till today. As on Lord 25, 25, Supreme Court legislated law again, not reverting back to the old quota. That is not 50, 25, 25. As enumerated in 2002, 10, Supreme Court. Also, I have produced in the list of citation. Also, I have produced that the Supreme Court, law declared by Supreme Court. Though it has no application, at least court must know when quota is fixed, what is the ratio among three sources. My lord will find page 15 and 16. I have given the entire picture of quota from change from time to time. Lord, 24,883 to 89 and 2005, 2/3, 1/3 quota. There is no competitive exam at that time fixed. 99 2005, 30, 112 2010. Lord, 50 by promotion, 25 by direct recruitment, 25 by promotion through limited competitive examination. Then Lord, 1/1 2011 till 19/5 2025. Till Supreme Court legislated the law, if the quota is 25, 65, 10. Then Lord, from 25.
Here it is changed, no? Not have promoted. With the same system of that, you would not have any
In the second volume, I have produced the judgment of the Supreme Court. I need not refer. I have produced the order of the apex court restoring the quota.
It's not in dispute a law.
That is second volume, Lord. All India Judges Association versus Union of India.
Page number have, sir?
Page number ಆಗಿದೆ ಎರಡನೇ ವಾಲ್ಯೂಮ್.
Page number?
Page 50, page 70, page 70. Paragraph 24. Volume 2 ದಲ್ಲಿ page 70 it commences with index. Not got it. Though it has no application to fact of this case, court must know when again the quota will change. Because my lord is laying down the law for future purpose also. I must not fail in my duty to point out that. That is my endeavor, my lord. Para 24, not page 78 commences. It has no application to on hand, but I am pointing out, my lord, since my lord is laying down the law.
That 3 months is over now.
ಆಗೋಗಿದೆ ಆಗೋಗಿದೆ ಲೆಜಿಸ್ಲೇಟ್ ಯಾವ ಮಾಡಿಲ್ಲ ಬಟ್ ಐ ಮಸ್ಟ್ ಪಾಯಿಂಟ್ ಔಟ್ ಟು ಯು ಲಾರ್ಡ್ while disposing the lord reference only my lord has to refer all these things and say what is the future purpose how court should registry should act anta that's all my endeavor not that not
Necessary.
yes 3 ತಿಂಗಳು ಆಗೋಗಿದೆ ಐ ನಾಟ್ ಸೇಯಿಂಗ್ not that but court must be apprised of this is the law declared by apex court.
ಇಲ್ಲ ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಪ್ರಕಾರ 14 ವರ್ಷ ಆಗೋಗಿದೆ.
2002 ದಲ್ಲಿ ಅವರು 31/3/2003 ಕೊಟ್ಟರು.
ಸೆಕೆಂಡ್ ಜೀಸಸ್ ಕೇಸ್ ಅಲ್ಲ, ಆಲ್ ಇಂಡಿಯಾ ಸೆಕೆಂಡ್ ಜೀಸಸ್ ಕೇಸ್.
ಹೌದು,
ಅವಾಗಿಂದ ಏನು ಮಾಡಿ
ಅದು ಆಗ್ಲಿಲ್ಲ. ಎಷ್ಟು ಟೆಂಡರ್ ಜಡ್ಜ್ಮೆಂಟ್ ಆದ್ರೂ ಆ 40 ಪಾಯಿಂಟ್ ರೋಸ್ಟರ್ ಇಂಪ್ಲಿಮೆಂಟ್ ಆಗಿಲ್ಲ. ಇವಾಗ 19/11/25 ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಲೆಜಿಸ್ಲೇಟೆಡ್ ಇಲ್ಲ ಈ ತರ ಮಾಡ್ಬೇಕು ಅಂತ. 4 ಪಾಯಿಂಟ್ ರೋಸ್ಟರ್ ಐ ಪಾಯಿಂಟೆಡ್ ಔಟ್ ಹೌ ರೋಸ್ಟರ್ ವಿಲ್ ವರ್ಕ್ಔಟ್ ಅಂತ. ಜಸ್ಟ್ 4 ಪಾಯಿಂಟ್ ನಾನು ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಿದ್ದೇನೆ. ಇಲ್ಲಿ ಪ್ಯಾರಾ 70 ಅದರಲ್ಲಿ ಪ್ಯಾರಾ 24 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಪ್ರೋಲಿ ಒಂದು
57.
Kindly see, my lord, para 24.
Yes.
what we find is that LDC is restored to 25 in originally recommended in third AIJA case, which was reduced to 10%. Kindly note it. In fourth AJA case, it will provide an incentive amongst officers in the civil judge senior division. It will also provide them an opportunity to get accelerated promotion in the Cadre district judge if they are meritorious and deserving. ಅಂದ್ರೆ 10ರಿಂದ ಮತ್ತೆ they go back to 25%.
We can say, court cannot say.
But though I feel that Supreme Court consistently did not declare law, but my lord, this bench cannot do because in 2002 Supreme Court said this. In exactly, my lord, now Supreme Court 23, up, my lord, judgment is dated 25 20th May 25. ಅಲ್ಲಿವರೆಗೆ ಅದು ಅದೇ ಕೋಟ ಇತ್ತು. $65, 10 and 25 ಇತ್ತಲ್ಲ, ಇವಾಗ ಮತ್ತೆ ಅಗೇನ್ ನಾಟ್ ಗೋ ಬ್ಯಾಕ್ ಟು 2002. ಮಾಡಿದ್ರಲ್ಲ, 3 months ಆಲ್ರೆಡಿ ಎಕ್ಸ್ಪೈರ್ಡ್ ಮಾಡಿ. ಪ್ಯಾರಾ 89 ಅಲ್ಲಿ ಕನ್ಕ್ಲೂಷನ್ ಕೊಡ್ತಾರೆ ಅದಕ್ಕೆ ಎಷ್ಟು ಅಂತ ಪರ್ಸೆಂಟೇಜ್ ನೋಡಿ. ಅದು ಒಂದೇ ಚೇಂಜ್ ಆದ ಮತ್ತೇನಿಲ್ಲ, ಡೈರೆಕ್ಟ್ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಚೇಂಜ್ ಆಗಿಲ್ಲ ಕೋಟ. ಪೇಜ್ 126 ಪ್ಯಾರಾ 89 ಕನ್ಕ್ಲೂಷನ್ 89(1) ಮಿಲಾಡ್ ಖಂಡಿಸಿ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಖಂಡಿತ. All the high courts and state government in country shall amend the relevant service rules to the effect that quota of reservation for LDCE for promotion from the cadre of civil judge senior division to the higher judicial service is increased to 25%. But law is declared. There is a positive direction to amend it. All the high courts and state government in the country shall amend the relevant rules to the effect that minimum qualifying service required to appear in the LDC for promotion from the cadre of civil judge senior division to higher judiciary be reduced to 3 years. This again, my lord, Supreme Court reverting back again to re-examine this question, my lord. Again, yes, ma'am. Total service required to be undertaken, including service rendered as a civil judge junior division, civil judge senior division, is set at minimum 7 years service.
This is under review now.
Again, my lord, now review is pending on this question. On this question. But my personal opinion, my lord, 3 years service is according to me necessary. Otherwise, my lord, they do not know pass out law. He may distinguish, he might have got in the my lord degree, but to maintain an order sheet at least, my lord, he must, my lord, they must practice minimum, my lord. It's my personal opinion, not that, my lord. Then, madam.
Supreme Court review is pending.
But only
Get it
this
this-
law, is it?
Last page 131 ಅಲ್ಲಿ 3 months further period of 3 months ಅಂತ ಹೇಳ್ತಾರೆ. Page 131. ಅದು 2002 2010 ಅಲ್ಲಿ ಮಾತ್ರ ಹೇಳ್ಬಿಟ್ರು ಅವರು. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಸೆಡ್ If you don't amend within such date, law declared by this court will prevail ಅಂತ ಮಾಡಿ 1/1/2011 ಗ್ಯಾಪ್ ಕೊಟ್ಟರು ಅಂದ್ರೆ ಲಾ ಡಿಕ್ಲೇರ್ ಬೈ ಅಪೆಕ್ಸ್ ಕೋರ್ಟ್. ಇಲ್ಲಿ ಡಿಕ್ಲರೇಷನ್ ಮಾಡಿದ್ರು ಸಹ ಸ್ಟೇಟ್ ಗವರ್ಮೆಂಟ್ ಅಂಡ್ ಹೈಕೋರ್ಟ್ ಶುಡ್ ಅಮೆಂಡ್ ದಿ ಲಾ ವಿತ್ 3 months ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಬಟ್ ಫರ್ದರ್ ಏನು ಡಿಕ್ಲರೇಷನ್ ಕೊಟ್ಟಿಲ್ಲ. This is rendered by Lord. Page 70 of judgment is 3 judges. Page 133 next judgment is Lord 5 judges. Lord. I did not explain that. That is the rated judgment of Supreme Court Lord on 19/11/25. I already explained to your Lordship Lord how 4-point roster shall be maintained. But declared the law prospectively from 19/11/25.
If direct recruitment does not happen within 1 year, it should be.
I already Lord explained to your Lordship. If direct recruitment doesn't take place within the same year, then Lord, they are entitled to seniority from the date of notification. Notification. If this law, the 1911 would have been applied probably the end the litigation would have ended the litigation. But Supreme Court said no, prospectively you apply this. The para 97 I already read out to your Lordship. I did not read again according to me. My Lord will find I explained the 4-point roster also to your Lordship. Should I explain, my Lord, again?
It's clear.
Yes. Therefore, my submission to your Lordship is, Lord, the quota shall be maintained from 24/8/83, 1/3 direct recruit is 2/3 promotees. Then, my Lord, 9/9, Lord, 2005 till 31/12/2010, Lord, 65, 50, 25, 25. 50 promotee, 25 Lord, direct recruitment, 25 by promotion through limited competitive. Then, my Lord, again on 1/11/2011 to 19/9/2005, 65 promotees, 10 competitive examination, 25 DR. Again, Lord, 25/25, the old 2002 Lord, where rule was amended, but in the same fashion. That means, Lord, 9/9/2005 rule is now restored. No change in DR and Lord, DR is concerned. Only limited competitive examination concerned, 10 to 25. Then, my Lord, my submission to your Lordship is, Lord, this is how quota shall be maintained by the registry of this court, strictly. Showing the statement of, Lord, post bar vacancies. The recruitment rule says post, but however, division bench of this court, I explained to your Lordship, they said you prepare a seniority list in accordance with the principle laid down in V.V. Badami was state of Mysore and as per the Karnataka government seniority rules, which is applicable to, Lord, the district judges. But I already explained to your Lordship, Lord, 1983 Rule 3 would, Lord, indicates, Lord, that all rules promulgated by any law or rule framed under 309 is applicable to the district judges. But general recruitment is concerned, only certain provisions are applicable. Not all, not all, not all. Again, my Lord, in the year 2005 also, I pointed out to Rule 11, same proviso at 1983. All the provisions, all declared under any law or, Lord, rule declared under 309 of the Constitution is applicable to district judges. In 2005, also, my lord, no change. In my lord, 2011 is concerned, only change in my lord, quota. Change in quota. 2010 Supreme Court. 1/1/2011, that quota came into effect. Change in quota, which is applicable to the present recruitment. Because quota is not changed, but LDC is concerned, it is changed in 25. What I showed you last 25 May 25. Then, Lord, in the instant case, my Lord, the High Court filed a reply statement. Lord. Private respondents who are the appellants in other appeal, my Lord, they have not filed reply statement nor contested in the petition. They filed appeal. Before the division bench also, I did not argue the necessary parties and etc. Though there are proper parties are made, not 3 to 12 to 82 are necessary parties, we have made them because they may push down in the process of preparing the seniority list if quota is properly maintained. That is our contention. Not that we are claiming our seniority prior to our recruitment. No. Only question is whether quota is breached or not. Only, my lord, suppose quota is properly maintained, data applicability promotees will be postponed. They will be pushed down to next block, nothing else. Nobody will be reverted.
Not from the date of their promotion.
But we will not get the prior date applicability. No. We are getting the same date applicability on which date we are recruited, from which date we are appointed, that is 1/2/2016. Whereas promotee's date applicability will be changed, nothing else. Nothing else. They cannot get the same date applicability from the date of their promotion. It will be postponed to subsequent date. What date is to be determined by the registry of this court. High Court has taken a specific contention in the reply statement. How it is prepared? Though I already showed you last annexure A and N, but it is nothing but a civil list. Only name of the district judges are enlisted in the seniority list, nothing else. Nothing could be found. Because my lord will find annexure A, no date, nothing. It commences from 338. Ends at some serial number recording the date of appointment, date of promotion. But I also explained to your lordship why the respondent 4 to 12 are pushed down. High Court rightly said in the reply statement, while preparing the seniority list, we have taken the date of entry into service and date of promotion. Date of promotion. Therefore, while the division bench principle is followed and seniority list was published in 2016, it was withdrawn. It was withdrawn. Subsequently, my lord, again during the pendency, in 22, final list was prepared, which was also questioned and amended writ petition is filed. Amended writ petition is filed. 4 to 12 are pushed down. Why? Because they were promoted on 4/3/2016. Kindly note the date. Why they are pushed down? 4/3/2016, where we are recruited on 1/2/2016. Kindly note the date. So, High Court's reply is very clear: date of entry into service, either by direct recruitment or promotion. Nothing else. What they want to justify now is, look here, 314 posts were there. Where it is reflected in the seniority list. It is not reflected, my lord. Nor, my lord, notifications are produced before renouncing the judge, not while pronouncing judgment. No. Only it was produced on 8, 9, not 25, while, my lord, before the division bench. When division bench directed and produced it. They produce all orders. Temporary creation of post. 8, 10, I think, I remember 2025. Not even before renouncing a judge. Those my lord, documents are available. No. Only before the division bench. No, my lord, page 611, I just point out to your lordship, my lord. There. Reply of the High Court. Page 610, para 34, my lord.
Date of eligibility may not be always the date of promotion.
Not page 611, Lord. In particularly that particular reply, where they admit, thereafter they explain this. I'll come to that. Page 611, Lord. What is the admission made by the High Court? The final seniority list, Lord, got it, is prepared according to the date of entry of service, comma, date of promotion as district judge. This is the admitted fact. Only we have taken date of entry, date of promotion. Would it be a seniority list? No. Then they explain in 35, my lord, this is the quota. Would it be reflected, my lord, in my lord, seniority list? No. Whereas, my lord, before the division bench, my lord, they have produced annexure P, which was R1. Annexure P, my lord, will find the list produced by the honorable, my lord, registry of this court before the division bench. Annexure P, my lord, page 655, my lord. Annexure, it was marked as annexure R1. Whereas the respondents have produced annexure P. That is not disputed by them. High Court has not disputed this. They say, yes, we have produced. And you see, page 654, my lord, admission of the High Court is, my lord, got it, my lord. 1/1/2003, my lord. Can you see the quota, my lord? 62, 2/3, 33, 1/3, my lord. My lord, got it, my lord.
Yes.
Then, my lord, statement of, my lord, they say vacancies, they say vacancies. This, Lord, block period 1/1/2003, Lord, 1/2/2003, 1/3/2003, Lord, go on like this, Lord. Then, my Lord, will come to change of quota. My Lord, page 658, Lord. My Lord, got it, Lord. But this is admission of the High Court, Lord, in the earlier litigation. Lord, will find Karnataka Judicial Service Recruitment Rules 2004 came into force. While government notification 9/9/2005, Lord, got it?
But
Page 658.
why have they said vacancy position?
That's why, my Lord. Division bench says to give vacancy position. Division bench laid down the law. VV Badami would apply. That I will point out. Division bench says, my Lord, Badami would apply. But recruitment rule says, my Lord, total number of posts. My Lord, may I kindly distinguish between the principal and division bench? My Lord is examining this. Therefore, High Court has given vacancy position, Lord. Vacancy position. And you see, Lord, the next, Lord, 50, 25, 25, Lord, got it, Lord. Page 658, Lord. Serial number, Lord, it commences from again 1 anta, Lord, it commences from 1, Lord. Got it, Lord. Page 658, Lord, up to, Lord, 19/2005, same quota will, according to them. They say, Lord, vacancies. What they have given is vacancies, Lord. Then, Lord, below, Lord, amendment took place, Lord, 2004, Lord. Then, Lord, quota is changed, Lord. Again, it commences from 1 only, Lord. Lord, got it? 1/10/2005, Lord, how it is worded. Page 658, Lord. $658, Lord. My Lord will find up to 19, Lord, I have already given you, Lordship, Lord, how quota will operate. From 24/8/1980 through 1/9/2005, I already explained to you, Lordship, Lord, 2/3, 1/3 quota. Then, Lord, again, Lord, the quota changed on 1/10/2005, Lord. Next column it says. Again, it commences serial number 1 only. My Lord, got it? That commences, Lord, 1/10/2005. Quota is 25, 25, 50. Lord. What I narrated in brief notes, Lord, is a fact, Lord, which is admitted by High Court. Then, my Lord, here they say vacancies, Lord. Vacancies. They statement of vacancies they say, Lord, because Badami says vacancies. Then, my Lord, page 659, 660, 61. Then, my Lord, $668, 668, not probably, not
Changes again.
quota ends, Lord. That is 50, 25, 25, 50 only, Lord. Page 668. Then, Lord, 669, only typed copy are produced, Lord. For reference, they have produced a typed copy. For 655 to, Lord, 668, High Court has given the vacancy position, Lord, not the first vacancy position. My Lord, got it, Lord, page 668. It will end on 1/10/2010, Lord. That's all. Therefore, my Lord, I am asking to redo the seniority list. If probably statement of this would have not after that, after this period, if High Court maintained the registry, they would have produced him, Lord, statement of vacancies or post, whatever may be.
These are vacancies, not vacancies.
After,
Yes, Lord.
they have not given subsequent.
No, Lord. Nothing is given. They produce the notification, that's all. These are the temporary posts created, we have taken into account.
Not the vacancy wise.
This has been referred in division by R1. Annexure P is R1. Lord. Afterwards, they are not given this statement at all. But when I filed, तो कुड़कते दमन मत तो कुड़कते रिजॉइंडर फाइल आगे सो रिजॉइंडर आगे तरह हेलो
Rejoinder ले
314 पोस्ट कर सर रिजॉइंडर कोर्स होने लगे
दिन ठीक है record इकडे तुम्ही
पेज नोड रिजॉइंडर मैंने रहा रिजॉइंडर मैंने रिजॉइंडर आगे मैंने it's a rejoinder
Yes.
737
I mean, no.
Yes.
But when they filed a reply, I filed rejoinder, not page 635, giving the statement of vacancy they have given in the before the division bench. Page 635, not kindly see the rejoinder filed by this respondent.
Page
635. 635. This annexure P is produced in the rejoinder. Page 635.
This is for rejoinder.
This is a rejoinder to the reply. Filed on 27/3/23, my lord, page 653. Producing annexure P. Contending, my lord, that you have admitted this. This is the statement of vacancies you have filed before the division bench, annexure R1, and P is produced, marked as P. Then they thought of filing a sir rejoinder. Sir rejoinder. Justifying the, again, my lord, seniority list. That is page 737 is a sir rejoinder, my lord. 737 in the same volume. Kindly see, my lord, 737, my lord. Sir rejoinder filed by the respondent 3.
Appellant.
That is appellant here, first appellant hearing. That's the registry of this court. But sir rejoinder is concerned, my lord, I did not object because technicality will not stand, because sir rejoinder is only found in CPC, my lord. Only we can, with the permission of the court, Lord, rejoinder, sir rejoinder can be filed. But I did not object. But now they are justifying 314 imports were there, and though they did not produce the notification, now they say, my lord, page 740. My lord, kindly see para 9. Now they justify the seniority list, stating that 314 post was the Cadre tanks. Kindly note, no documents are produced. But para 9, kindly note it, my lord, page 740. Promotion order. Para 9, 740, my lord, kindly see, now they take a contention. 314 post was a Cadre tank, but there was no government order produced. I mean, creation of post is produced. They justify it, my lord. The seniority is before this court. Could they? Can order of the registry will become better when it becomes older? No. Orders are not like old wine, which grew better when it becomes older. No, my lord, judge justifies by Sir Rejoinder. Look here, 314 post. No, but no government or justifying 314 post, only before the division bench. All government orders produced before the division bench. Like rightly learned thing, judge find please redraw it. It is not drawn according to seniority rules and quota. But learned thing, judge never said you push down, no. Or nor he said you redraw it. That's all. Redo it. But this rejoinder, they are justifying, there are 314, no documents are produced. What they have produced, my lord, is the date of promotion. Kindly take with 746. Respondents, lord, respondents 12 to 14 before the listing, the judge are promoted as district judge in different dates. That we have taken into consideration, not the quota. Page, lord, 746 is the one promotion order. It contains, that is, lord, 30th March 2015. Lord, got it? 746. One promotion order containing 35 names. That is 30th March 2015. Annexure, lord, page 746. R1. Then R2. 30th August 2015. That is, they are the respondents, lord. 41 names. Respondent blood, R2 is 39 to 42. All of them are parties. 82. All of them are parties. So what is necessary in the Malad in a seniority matter, Malad? I can only implement two. What Supreme Court said in the matter of seniority, this court is laying down the principle. When you are questioning the basic principle of seniority, Malad, I need not make them as a parties. But by precaution, I made them a parties. All. Therefore, question of non-implementing necessary parties will never arise. No, it is not the plea of any of the appellants. But before this bench, they have taken that plea. That cannot be examined. My lord is not examining that. My lord is examining which view is correct. That's all. The annexure, lord, page 650. But neither the non-implement parties are not treated at all before the before the reader bench also. Can this bench not specially constitute for examining the view taken, which view is correct? Reference, that reference. Can they go into that question which is not raised? No. And even this court, even respondent cannot even imagine I have not made them parties. All of them are made them parties. I would have implemented 1 or 2, 3, but I have implemented all. Therefore, my lord, that question will never arise. But High Court's reply statement that date of promotion is taken into account, they are justifying by filing Sir Rejoinder. Look here, we are promoted on 38. That is the date of eligibility. That is the date of seniority. Since you are recruited in 1/2/2016, your date of eligibility 1/2. I'm not asking date of eligibility. You are pushed down. If it is not date of promotion, date of recruitment is concerned, seniority is not necessary at all. Just they make a civil list and publish it. Why not seniority dispute right from 1976, not till today? We are in Lord 24 plus Lord 26. How long, Lord? 50 years. Badami was pronounced by Supreme Court in 76, Lord. Maybe Badami was straight up also, which is reiterated, Lord, in 87 again. Still, we Lord, all the department again boiling in the same point. And Lord, the registry is also not accepted for that. That is what I am making my submission. But I need not show, I think again, we have also filed a reply to Sir Rejoinder. I don't think, Malad, it is necessary because, Malad, Sir Rejoined itself, they say first time 314 post, but no documents are produced. ಇಲ್ಲ ಮುಗೀತಲ್ಲ. Point 1 by point 2 only. Next.
These additional pleadings
Yes, Lord. Yes, Lord.
were filed.
By the High Court, Lord. Nobody else. And we have filed reply. Then, my Lord, we have filed rejoinder. They have filed Sir Rejoinder. Again, my Lord, we have filed reply to Sir Rejoinder. There are totally petition, reply, rejoinder, Sir Rejoinder, then the reply. These are the pleadings. But no private respondent who has appellant filed, my Lord, reply statement, nor they will not contest the case. Yes, my Lord. All these things are before single judge, my Lord. Therefore, one thing which is said, you please redo it. Never said.
It's not there with the single judge. I thought so.
Now the rejoinder and Sir Rejoinder
Yes, my Lord.
were filed before the single judge.
Yes, my Lord. Even the dissenting view refers that, my Lord. Dissenting view of the senior judge refers the, my Lord, Sir Rejoinder. Say 314 post. Now they have produced the document. It is referred. My Lord. It is referred. Both judges have referred.
Only the seniority list is produced before the division bench.
Yes, my Lord. That is notification.
That's it.
That's all.
Remaining all other pleadings are.
Yes,
before
my
the
Lord.
single
That. So nothing is wrong with the not anything the judge, nor with the view taken by the other judge also, according to me. But my Lord has to further lay down the law in this case. For future reference, at least registry should correct everything so that, my Lord, the seniority concerned, it will end. My Lord is examining the larger question. Larger question. Even division bench, my Lord, says vacancies. I pointed out. I point out again to your Lordship. Division bench by redo, my Lord, direction to redo the seniority list says Badami, the principle laid down by VB Badami would apply. I point out to your Lordship. Division bench says so. But recruitment rules I pointed out admit also that total number of posts solely, not the vacancies. Because I must say fairly, whether I go up or go down is immaterial for me. But let this court lay down the law, correct law at least. Lord, the page 16, Lord, seniority list.
Yes.
Lord, the High Court has not produced any statement which was R1, which is P, as it was produced before the division bench. Never. Here, up to 1/1/2010, I showed your Lordship, High Court maintained some registry according to me. statement of post or vacancies, whatever form, whatever the form. It may be post, it may be vacancies. According to them, it is vacancies. Probably High Court has to explain that, according to me, which is admitted by them.
So there's no consolidated list
At all, my lord.
like the earlier one.
Yes, my lord.
After 2010, it's only their interpretation.
Yes, my lord. That is only 2012. That is the last list which was quashed by Lord Single Judge. Division bench says you do it. That list is also not correct. So none of the seniority list has attained finality, my lord. That too after seniority is prepared according to division bench, withdrawn, best down to the Lord High Court. I mean registry. In the year 21, my lord, I showed your lordship. July 2016, final list annexure A was prepared according to them. Now 21, they have withdrawn the seniority list, published the provisional list, then finalized in 22. So division bench spent its force in July 2016. It was withdrawn. Then, my lord, objection is filed, list was finalized. We have amended the writ petition to quash the seniority list prepared in Lord 2022, annexure N, annexure N. Also, that is 16/3/2022. But seniority list, annexure A or N is silent, maintaining quota of 65, 25, and 10. Nowhere, even a statement of post or vacancies they give along with the seniority list. Probably I would have pointed out before your lordship, or before the single judge, or before your lordship. Now we are imagining certain facts, 314 posts, that this is the bifurcation. No. If it is reflected in the seniority list, this court would have laid the correct law. It is not reflected. It is not the duty of this court not to say so, also according to me. This court, according to me, simply can say seniority list is not done according to, redraw it, what is the principle. It is the duty of the registry to work out quota in the ratio of Lord amended from time to time. Then, Lord, the Supreme Court in Rajendra Kumar Srivastava, Lord Srivas, which I have produced, blood, held blood, quota shall be maintained according to the recruitment principle, not amending from time to time, including the LDCE. None of the quota shall be breached. This court was apprised of Lord state of Karnataka was Chikkabaswaya. The Lord will remember division bench of this court, where it was explained by the appellants, private respondent appellants before your lordship, Lord, producing the Lord judgment. Lord, kindly take the judgment, how it does not apply on hands. I will explain to your lordship, Lord. Volume 1, produced by the Lord appellants in appeal number 1162. What is the principle laid down by Lord in the Lord Chikkabasavaya and others, which is applicable, Lord, only to secretariat service? Kindly note it. Between the question was, Lord, from Lord, seniority between the direct to assistants, Lord, and promotee assistants. What is the law laid down by my lord, division bench, my lord? Division bench is, my lord, departing from the V.V. Badami's case. V.V. Badami says, my lord, total vacancy shall be taken into account while classifying the vacancies. But Chikkapasavya, my lord, say, enumerates, my lord, what it enumerates is, my lord, utilization of vacancies shall be taken into account for a particular year. For example, my lord, how it is. But total cadre strength is, my lord, for example, my lord, 50 vacancies, my lord. 50 vacancies. Rule says 50-50, my lord. So 50 vacancies, my lord, 25 promotee, 25 direct recruitment, my lord. But promotion is concerned every time they achieve the quota, my lord, in all the department. My lord will remember even judiciary also achieves always access they will make. In every department, my lord, promotion time it will be affected time to time. Then, my lord, what the division bench says is only utilization. That means out of 50, my lord, 40 filled up. 40, please divide into 20-20.
But that is in the absence of a rule.
No, my lord.
No, what I'm saying,
Ah.
suppose in our case, the rule says out of the total post,
Yes, my lord.
there ends the matter.
Yes.
Any interpretation contrary to that cannot.
Yes, my lord. Lord, why, my lord?
I think prima facie.
My lord is right. Here, vacancy only. HM Chikkapasavya, State of Karnataka, my lord, versus Chikkapasavya says, utilization shall be taken into account, not the total number of vacancies. Because it will cause injustice to the direct recruitees. Total 50 vacancy, for example, 25 is quota for promotees. For example, I am giving an example. 25 they can fill up. But DR is concerned, nobody achieved the quota. Here 50-50, 2/3, 1/3, then amended to 50-50 in this case. Not in Chikkapasavya's case, earlier 66 2/3, 33 1/3, then 50-50 among promotee assistant and assistant. Division bench says, not the utilization. What is the utilization each year? Shall be the block period. Take into account the only filled up post. That means out of 50, 40 are, for example, not filled up. Only you divide into 20-20, nothing else. But Badami says, Lord, total vacancy you take. That means 25 you can give it to promotees, notwithstanding non-filling up the quota for DR. Blood. Notwithstanding the not filling up the post DR, you can give 25 vacancies. But Chikkapasavya says, no. Whatever vacancy utilized, divide into 50-50. Each year shall be the block period. For the,
But even Chikkapasavya's case, there was no clarity in the rule.
no, my lord.
But as of now, the rule is clear.
Yes, no, that is clear. From not 83 to not 2005, not 2005 onwards, rule is very clear. 2011 also rule is very clear. Not, no ambiguous. Only ambiguity is in 83 rules. Some ambiguity is there, but not division bench of this court has cleared that. And single judge Shambhu also has not cleared the doubt. 1/3 only.
Doubts still remain.
According to me, doubt will not. Why? Because Shambhu is very clear. Full court of this court has taken a conscious decision on 3/11/87. Division bench also para 60 says High Court admitted. But that is very clear from the statement of annexure P, not statement of vacancies, not which I showed you, Lordship. Regarding quota is concerned, High Court admits. Which is the admission of the High Court. So Chikkapathavai, a principle laid down in Chikkapathavai has no application. Lord, why? Because it says only utilization, nothing else. May I show the even last direction also to show that what is the direction in Chikkapathavai's case. My Lord will find page 18. Lord, the first para 47. Lord, first direction is you maintain that quota 66 2/3. Lord, got it? Page 47. Lord, C, D is very important. That is utilization of vacancies. Lord. Kindly see how it is worded. The number of appointments made to the care of assistant during the period from 12th March 60 to 25th July shall be classified as direct recruitment post and promotion post in the ratio of 1:1. That means number of appointments made. Kindly note it. That is utilization of vacancies, either by a promotion or direct recruitment. This principle would apply only in secretariat, not other department. Other department is called VV Badami holds the field. No, my lord, in your RK Sabruwala's case, my lord, in 21, my lord, all departments shall follow the principles based on not vacancy, based on post only. That is RK Sabruwala, rendered in 95. State government Lord adopted to KAS in 2016. Other department 21. 95 direction was passed. 21 Lord, it adopted the vacancy, not vacancy, based on post only, notwithstanding the recruitment rules.
So, but here, our recruitment rules refer to total.
Post. But that's why beginning itself I told division bench also maybe it is wrong to say that PV Badami would apply. I find out your lordship. Still I say what is the division bench ruling? It is a fact that division bench said PV Badami would apply. I will find out to your lordship when it comes to the later point. Now Chikkapathavai is concerned only, but I explained to this court it applies to secretariat service. Principle is I gave an example utilization theory would be applicable, not the actual not the total cadre vacancy, not the total number of vacancies. No, only utilization. Each year shall be the block period. That is what the Dissenting says. Dissenting says. My lord will find E. E is each year block period. But VV Badami says, my lord, block period will be commencing from one recruitment to another recruitment or amendment take place. How block period in VV Badami was a state of Mysore says so. What is the principle laid down by effect court? But I have produced the government order also, 76 government order, in the list of enactments. I have produced it. I showed your lordship, vacancy based principle is adopted by Supreme Court. No, my lord, RK Subrawala is a 5-judge bench. Therefore, the state of Karnataka, passed executive order saying post-based principles shall be applicable. In Karnataka, as decision is concerned, it is the recruitment to says only post, not the vacancies. Because this court may look at the division bench principle, say VV Badami says so, division bench says so, VV Badami would be applicable. But my lord is examining whether post-based or vacancy-based. Kindly note it this. My lord has to distinguish the principle laid down by the division bench according to me. It is the post-based which the recruitment rule says so. My lord, the quota shall be maintained to the, my lord, page 18, my lord. Point number 4. Quota shall be applied total number of post district judge entry level alone. Kindly note it, my lord. Why I am making this restriction, my lord? 83 rule itself says super time scale post is different. My lord, kindly note it. Supreme Court says, my lord, entry level post, selection grade post, and my lord, super time scale post. These are the 3 posts existing, which is legislated by the FX Code. Government order is passed on 24/2/2006, giving effect from 1796, which I have produced before Lordship, my lord, enlightened the government order also. This law not selection grade is a promotion post from the grade of district entry level. Super time scale is a promotion post from the post of selection grade district judge. Lord. Kindly appreciate this. Lord. What is promotion? It may be a grade, it may be a post, it may be a grade. That is what the definition of promotion. Definition of promotion. Under the general recruitment rules, from grade of service or class of service to higher post. That is the promotion definition. Therefore, my lord, district judge entry level is one pay scale. District selection grade is another pay scale, promotion pay scale. District super time scale is another pay scale. Fixed by the FX Code, accepting Honorable Justice Shetty's pay commission. Now that is, my lord, exactly government order 22/4/2006 says, my lord, 25% of the career of district judge entry level shall be reserved for selection grade, 10% for the super time scale. Totally 35% shall be set apart for that. Under the, my lord, total district judge strength cadre. My lord, how I have worked out? Page 21. My lord, got it? Not admitting 314 post, my lord. I have given 2 tables.
But this exercise,
Yes.
the cadre itself is not quantified.
Yes, my lord.
It's difficult to enter into any exercise.
Correct. But I am showing how it should be worked out. But I'm not saying your lordship should accept my table. No. But I am making my endeavor how it works out. Because they have shown. But I only, my endeavor is, my lord, kindly see, total number of posts, not admitting 314 posts, kindly, how it worked out. But I already, Lord, explained to your Lord Shambulingappa's case, para 9. At that time, super time scale, 20 posts where it is excluded from the entry level. My Lord got it, not? Shambulingappa's para 9. Where, while examining that, not division, single judge, my Lord, refers to the 83 rules, says, super time scale, please exclude that under the entry level. Lord, I have worked out from, my Lord, total 314 posts, my Lord, less, my Lord, the 32 post, temporary post excluded this table, my Lord, total 282. Lord, I have divided among 25, 10 and Lord 65 because there was a quota at that time. Lord, got it, Lord. Roughly, Lord, I worked out totally, Lord, the 10% post comes to, my Lord, will find the 28 post. Then, my Lord, promotion, my Lord, page 22. My Lord, got it. 65% quota, 120 post, my Lord. Then number of promotees working as on 1 and 2, 193. Excess promotion under 65% quota, I have worked out. Then, my Lord, I have worked out table B. What is table B says, my Lord? Without considering temporary post, my Lord. Table A, Lord, including temporary post I worked out, not admitting that fact. Table B exclusion of 32 temporary post because the learned judge says they have given the total number of 314, rightly quota is meant. That is what the finding of the one of the judges in the division bench. Therefore, I have to give this lot table. But kindly see B. B is concerned only 60. A is concerned 73. Then, my lord, page 23, I have called out the, my lord, para 17 of the Shambulingappa's case where learned judge refers that super time scale is concerned, it shall be excluded from the district judge entry. My lord, got it, page 23. Total post B. But I have given both table to show that how it should be worked out. Accepting or accepting this left to this bench to give a finding of excess, my lord, probably my lord has to refer this if my argument is accepted. Otherwise, my lord, the table A and B I have given for the convenience of the court how it should be worked out according to my lord effect court judgment and government order 24/2, but 23/4/2006 both. Table A including temporary post, table B excluding temporary post. Not 60 is excess. Then my lord will find page 23, Shambulingappa's case, my lord, para 17 is referred to exclude the
Yes.
then my lord, the page 23, I made out the, my lord, I have narrated the district judge source of recruitment, 3 source, how it should be worked out, how super time scale should be worked out, excluding the entry level, selection grade, it shall be excluded according to the quota. Then my lord, Karnataka government seniority rules 57 applicable to district judge in the state of Karnataka. My lord, I have already referred rule 3(2) of the 1983 rules, which says, my lord, all the law declared, all the rules declared under law or any rule declared under rule 309 of the Constitution is applicable to the district judge cadre. Not only district judge, not junior, civil judge junior division, civil judge senior division, district judge also. Lord, page 24, my lord, I have just referred rule 3(2) of the, my lord, 83 rules. I have referred rule 2 of the Karnataka government seniority rules, how, my lord, seniority shall be prepared. Then, my lord, 3(2) of the 83 rules, 11(2) of the 2004 rules, my lord. My lord, these are all the rules framed within the framework of Article 233 and 34 and 35 of the Constitution of India. Because I already explained to your lordship, my lord, 233 is concerned, it only says, my lord, appointment of a district judge, how it should be, not quota is not maintained. Either promotion or direct recruitment, they can make appointment. But mode of recruitment is concerned, it is not, my lord, it is not there in Article 233 at all.
There is also,
Yes.
in all these acts, the preamble is faulty.
Yes.
The power under 233, 234
Yes, Lord.
relates only to recruitment.
Yes, Lord.
There is the difference between recruitment and conditions of service. 309 proviso deals with conditions of service.
Yes, Lord.
But when they trace the power, they are not appropriately tracing
No,
the
Lord.
power in any
Every rule they say 1978 they refer, Lord. 19, Lord, what happened, Lord? Article 309 was promulgated to frame recruitment tools by the governor, which is transitory until each state declares the law regulating service condition of the government servant. as for Karnataka state is concerned, Karnataka Civil Service Act 1978 is promulgated. After 7 years, assent was given. Lord, it has given effect to in 95. 78 Act. But C09 is only a transitory rules promulgated to be promulgated by the governor. But 78 Act, when they promulgated, Lord, they say, Lord, all rules promulgated by the governor, Lord, I showed your lordship, section 3, subclause so and so, is deemed to be a part of the until it is modified. Now, Lord, each recruitment rule says for 78 Act. That is wrong, Lord. I am not saying, Lord, Karnataka Civil Service Rule Act 1978 is applicable to the High Court or the DPR to promulgate the rules. No. Rules of recruitment shall be promulgated by the DPR. I showed your lordship, Lord, already. Karnataka allocation of Lord business rules 1977. Business transaction rules 1977. Both. Rule allocation of rule is concerned, DPR Lord, controls the finance, Lord, creation of post with the in conjunction with the finance department. That is allocation is concerned. High Court and District Judge, I showed your lordship, comes under DPAR. Therefore, DPAR is promulgating the rule in consultation with the Chief Justice. But 78 Act they refer each time. My Lord will find again to show that in the list of enactment which I have produced, my Lord, shows, my Lord, again refers to 78.
So now,
Yes, Lord.
the fact remains that the recruitment rules
Yes, Lord.
provide for adoption of state or other rules
Yes, Lord.
relating to conditions.
Correct, correct.
By virtue of that,
Yes.
seniority rules applicable to the government servant.
Yes,
made
Lord.
applicable.
Applicable to the district. That's what I am making my endeavor to say, not to say so. Not each time, Lord, 83, Lord, 2001, 11, 7, 2011 amendment is concerned. Again, they refer to Lord 78 Act. Lord. But as far as 83 rule is concerned, Lord, it refers to the provisions of law, Article 233, 34, and proviso to Article 309. 309. 83 rules are concerned. Rest of the rules are concerned, my Lord, again, they refer to Act, 1978 Act. My Lord, you'll find page 20. For first rule, 83, after 62, first rule was promulgated in 83. That is page 5, not in the list of enactment. Why I am emphasizing, Lord? Kindly see the preamble of the rules, Lord. Page 5. In exercise the power confirmed by Article 233, 234, and proviso to Article 309 of the Constitution of the Governor of the Karnataka, after consultation with the Karnataka Public Service Commission, High Court of Karnataka, make the following rules. Page 5, Lord. Lord, 83 rules they correctly refer to the provision of law. In my Lord, page 20, probably my Lord, while my Lord, 2000, my Lord, 5, page 16, while my Lord, the implementing the effects court judgment, my Lord, amending the quota 50, 25, 25, my Lord, page 16, they refer to the provisions of 1978 Act, my Lord, page 16, my Lord, got it? Not provision of law wrongly mentioned is immaterial. Whether Lord DPA or the Cadre High Court can change the rules or not. Not wrong, making Lord referring to wrong provision will not invalidate the Lord promulgated by the Lord DPR in consultation High Court. But 78 Act promulgation is concerned, my Lord, it has no application for promulgated. But The rules, recruitment rules says, Lord, whatever law promulgated under 78 Act is applicable to Lord Cadre of District Judge. Provisions of 78 Act is no application, but all rules promulgated under this Act is applicable. See, Karnataka government seniority rules, for example, KCS CCA rules 1957, and Lord Karnataka Lord conduct rules Lord 1977, amended in 21. Then Lord Karnataka provisional rules, right? All rules are applicable except certain provisions and the recruitment rules. Lord, again, Lord, in page 20, again, Lord, they promulgated the apex court judgment, which is 1/1/2011, referring to 1978 Act only, Lord. That is a wrong provision of law referred in the while promulgating the rule. Lord, page 16 and 20, both, my Lord, got it, Lord. Only my endeavor is, my Lord, wrong provision 78 Act is referred while promulgating the rules. It may be incorrect provisions, nothing else. Lord, now the Karnataka government seniority rules would be applicable, my Lord. Admittedly, division bench says so, my Lord. Para 66 to 68, my Lord. Therefore, my contention that, my Lord, the other law declared as no, doesn't apply, do not apply to the district judge, my Lord, or any other post, cannot be accepted. Because law itself, the recruitment rule itself mandates that this is the rule applicable. Why incorporation? Probably my Lord has come across the PDA Act. My Lord, there is no provision to pass award. But Section 36 of the PDA Act refers to the how awards must be passed. That is not provisions of Section 11 and 11A of the Lord. Land action mutatis would apply. While examining this provision of law in offshore case, my Lord will probably examine this while my Lord examining the acquisition. Lord, by incorporation, this Lord Land Acquisition Act would be applicable. That is what Supreme Court Constitutional Bench says so. But 11, Lord, 3(2) of the 1983 rules, 11 of the 11(2) of the Lord 2004 rules would clearly applicable all other rules in state of Karnataka, which is promulgated and 78 Act applies to District Judge Cadre. That is my endeavor, accepted by the division bench also. Para 66 to 68. But however, my Lord, the dissenting view of the senior judge, my Lord, at para 46 of the senior judge in the division bench, my Lord, gives a finding that other rules are inapplicable. Kindly note this, my Lord, which is incorrect. Division bench, para 46. Lord, division bench judgment, it is there, not on the file. Not para 46, not the dissenting view of the senior judge.
We don't know which is the dissenting view.
My lord has to decide whether assenting or dissenting view, because the senior judge differs with the view of the learned single judge and allows the appeal filed by the High Court. My lord. Therefore, while referring to say, my lord, my lord, I'll refer it to the opinion of the senior judge, my lord. Senior judge, para 46, my lord, is the finding, my lord, it is therefore clear that rules relating to reservation in appointment are made applicable to recruitments under the Karnataka Judicial Service as well as, however, since no specific rules which are made applicable are specified in the Karnataka Judicial Service recruitment rules themselves, in the reliance on those rules which are not specifically not applicable, circular and government orders rendered on the basis of those rules which provide applying the quota against arising vacancies are not applicable to appointment of district judges is a finding, which is on the face it is wrong. On the face. The recruitment itself says what are the other rules applicable. I pointed out to your lordship, other rules are applicable under rule 3.2 of the 83 rules, under 11.2 of the 2004 rules. Therefore, my lord, the finding of the the senior judge is not in accordance with the judicial recruitment rules of the district judges cadre, and also, my lord, contrary to law. Division bench mainly relies upon Kerala High Court division bench judgment, not the senior judge. Should I read the Kerala High Court judgment, my lord? Point out that only what was the examination of the Kerala High Court judgment, my lord? Division bench of the Kerala High Court judgment, though leave is granted, though there is no stay order, once leave is granted, Lord, this court normally will defer the not hearing, but the Kerala High Court judgment would, on the face, not applicable. Why? Because, Lord, para 4 of the Kerala High Court judgment, kindly take for a moment, Lord. List of citation, list of citation, second list of citation, first judgment. The first judgment I am not given in my second volume. Not why it has no application, because division bench of the Kerala High Court, my lord, examined the with reference to the government order promulgated by Kerala, my lord, in concern with Kerala High Court, my lord. May I draw your lordship attention to page 9, para 4, my lord. Page 9, para 4 in my list of citation, my lord. Before the Kerala my lord, High Court, volume 2, my lord, it is filed. Only finding is, my lord, with reference to government order passed by the Kerala state government in consultation with the High Court. But what is the definition of cadre strength there, my lord? Kindly note it, my lord. That is how it applies to our, my lord, judicial judge cadre. Because there is no government order. Common. This is a common government order. Common government order is passed. But no need to pass separate order each time, fixing the cadre strength. What Kerala government says in High Court is, my lord, page 10, my lord, it's called out. Not got it? Cadre strength, the Kerala government, my lord, in consulting the High Court, my lord, defines cadre strength by government order at 38/2014 is like this, my lord. Cadre strength means shall constitute all the sanctioned post of district and session judge, including additional district and session judge, all the sanctioned post of judges in the equivalent statute, all such other temporary existing for more than 6 months. Kindly note it. What, my lord, there is a general government order in the High Court defining cadre strength. Cadre strength means it includes both permanent post and temporary post, but existing more than 6 months. Kindly note it, my lord. That is, my lord, suppose, my lord, if this government order is there in state of Karnataka, I have absolutely no case to argue. Here, this is a government order. High Court duty is to, when once cadre strength, cadre is created, it is a part of cadre strength. If not vacancies, post shows more than 6 months. Kerala High Court said it is the ministerial duty of the registry when there is a government order holding ever no further notification is required, because it says both permanent and temporary. They are anything matter. Only showing this blood which are the posts created. That will be part of the cadre strength. But in Karnataka, blood, there is no government order in Karnataka High Court, blood, defining the cadre strength or fixing the cadre strength, except in 2001, which I showed your lordship in the list of enactments filed before your lordship, my lord, that is page 15, fixing the cadre strength of the enactments which I have produced along with the memo. Page 15, my lord. Third March 2001, my lord. Page 15, my lord, got it, my lord. Now, kindly see. In supersession of all existing order, Government of Karnataka hereby sanctions the establishment of state service cadre in for district judges in the Karnataka Judicial Service, strength of the said cadre and number, character of post born on then shall be as follows. District and session judge 20. Now kindly note it, super time scale. Kindly note it, district judge, session judge. My lord, total number of posts is, my lord, 46. My lord, got it? That was a notification, my lord, showing the cadre strength at that time.
But after this,
No notification. No, my lord. That is why, Lord, I am making my endeavor to show that after this, no notification is issued in Karnataka High Court fixing the cadre strength, my lord.
there is no clarity. What
My lord,
is
yes,
the
my lord.
extent after this 3rd March 2000.
No, my lord. This is an admitted position, admitted by the other appellants also, or High Court also, my lord. In the entire pleadings, my lord, it is not there, my lord. Nor it is, actually, it is not there, my lord. Except, my lord, producing the creation of post before the division bench, my lord. It becomes a part of cadre strength only when notified, my lord, by the DPR in consulting the High Court. But here in page 15, my lord, at that time, selection grade post is not there, my lord. My lord, I will remember 24/3/2006, when 2002 Supreme Court legislated the law, DPR High Court wrote a letter. FX Court rendered the judgment. Please pass this government order. reserving 25% of the total district judge entry level for selection grade, 10% for super time scale. That is, my lord, in 2006, which effect from 1796, which I already showed you, lordship, my lord. That government order, my lord, is page 36. My lord, page 39 is the district judge concern.
Yes.
Lord, this government order is issued in Karnataka High Court. Lord, earlier to Lord, 1978 Act, Lord, which came into force, Lord, in May 1990. Lord, Governor of State of Karnataka promulgated the recruitment rules. Cadre strength is concerned by executive order, Lord. Cadre strength will be fixed. That is the practice. That is the practice. But when Karnataka State Civil Service Act 1978 is promulgated, my lord, it is only by way of provisions, Lord, enumerated in 78 Act, which will not apply to the, Lord, promulgation of rules under the Karnataka Judicial Service Recruitment Rules, Lord, either 2005 or Lord, amended 2011. Because 78 is not the provision which would apply, though it defines, it applies to High Court employees. 1978 Act is concerned, regulating service conditions High Court employees, it is applicable.
So by default, according to you, it's the KCSR definition of cadre that would apply.
Yes, my lord. That is what I am making my endeavor. Rule 87, subclause 7 of the KCSR, read with Rule 49 of the KCSR. 8, subclause 7 of the KCSR defines cadre. It must be by notification. And what is a temporary post, my lord, is defined in Rule 49, Note 2 of the KCSR, which I already read over to your lordship. The post is created for particular purpose. Once it is achieved, it cannot be included in the cadre strength. I gave an example also. Trial of Miss Jayalalitha is concerned. It is meant for only no other cases. But for example, Lord, the special bench today, can it take any other matter? No, because it is a special bench meant for it.
Yes.
Lord, trial of Dandupalya. Lord, all this creation of post is, once the purpose is achieved, KCSR Rule 49 Note 2 says it cannot be. It purpose is concerned, it will be deemed to be abolished. That is what I read over to Rule 49 Note 2, Rule 87, subclause 7 of the KCSR defines
Yes.
Lord, Cadre means, my lord will find rule 8 of the KCSR, sub-rule, my lord, 7, lord, my lord got it? KCSR, no? My lord will find the rule 8 subclause 7. Cadre means, my lord got it? My lord, cadre means the strength of service or part of a service sanctioned as a separate unit. That means to say, my lord, impliedly there must be notification fixing the cadre strength of service. Rule 8 subclause 7, my lord. My lord got it? My lord? Yes. Then, my lord, definition of permanent post and temporary post is there, my lord, which may assist this court to define what is permanent post, what is temporary post to include in the cadre strength. Rule 8, subclause 34 defines permanent post. You not got it? 8, subclause 34. Permanent post means a post carrying a definite rate of pay sanctioned without time, not condition, without limit of time. That means no time limit will affect. It will be part of cadre strength. What is temporary post, my lord? Temporary post is defined under rule 8 subclause 46, which would assist this court to define what is cadre strength and what is the permanent post. Because my lord is laying down the law, the respect to the total number of posts in the district judge cadre, my lord. It is not post, my lord, vacancy based. It is a post based. Therefore, my lord has to take definition of my lord cadre, definition of no, definition of permanent post is rule 8, not 34. Permanent post without limit of time. Temporary post means rule 8 46 means post carrying a definite rate of pay sanctioned for a limited time. The appellant in other case was arguing, no, we are paid with salary, etc. Question is not that, my lord. Question is not temporary post also must carry certain pay scale. That is what definition of rule 846. But definite of pay sanctioned for a limited time. That is, my lord, limited time it will be created. Once the purpose is achieved, to deemed to be vacated, deemed to be abolished. But having regard to these rule 8, 7 and 34 and 46, only permanent alone shall be notified, or DPR in the High Court can notify both permanent and temporary post. I am not saying temporary post cannot be considered. If like there is a general order by Kerala government, probably would have solved the problem before this court. There was no such government order. Therefore, my lord, predicament of this court is now define what is cadre strength. It is not the duty of the High Court, not ministerial duty of High Court to fix the cadre strength, my lord. Once general government order is there, both permanent, temporary, High Court, it is duty, ministerial duty, High Court, register to, not say that this includes in cadre strength. Then nothing wrong. But here is the case, there must be notification. There is no such rule in, my lord, in Kerala Judicial Service. Like rule 3.2 and, my lord, 11.2 of the 2005 rules. There is a government order. Applying always, it is the not exhausting government order in Kerala High Court stating that cadre strength is both permanent, you take everything which post not lasting even 6 months. If it is less than 6 months, it cannot be included. That also says not Kerala High Court, not a government order, Kerala government order. Temporary post means minimum period must be 6 months. But here there is no such government order. My lord has to now lay down the law. Lord, Kerala High Court Division Bench examines that, Lord, that government order. Examination is, Lord, para 9, Lord, the last sentence in para 9. In the list of citation which I have given, Lord, page 13, the last sentence from bottom. Lord, it is not 38 2014. Lord, it is the government order in Kerala High Court is dated, Lord, 38 2016. Kindly note it, Lord. Para 9, Lord, last sentence will note it, Lord. Not got it? Page 13. Lord, in the beginning, court has quoted para 10 nalli, and page 10 nalli. Lord, kindly see 38 2014 anta madida. Kindly correct it as 38 2016. It is evident from para 9. Para 9 last sentence, Lord. The state thus, in consultation with the High Court, was fully competent to issue impugned order number dated 38. Thus, we cannot uphold the reasoning of any single judge. That means to say, state has issued government order dated 38 2006 in consultation with Kerala High Court. Therefore, there is no separate notification necessary to fix the cadre strength. It is the duty of the registry to ministry duty of the High Court to fix the cadre strength, whatever created post exceeding 6 months. If it is below 6 months, it will not be counted. And therefore, Kerala High Court judgment has absolutely no application. The reasoning of the senior judge, entire judgment relies upon this judgment, says appeal filed by High Court is allowed, which is totally, my lord, opposed to law in state of Karnataka. But I am making my endeavor to say, but here, in state of Karnataka is concerned, my lord has to say 25%, 24 for 2016 DPR in High Court implementing the FX court judgment say 25% of the district entry level. What is the cadre strength? Please minus 25, right? Count it for the purpose of divide it between the promotees and direct recruitees. That government order, my lord, in Kerala High Court is concerned, only interpreted that government. Not said no. No separate notification required. Temporary also includes, post also includes. That is what Kerala High Court said. It has absolutely no application. On facts.
Yes.
No, my lord. Therefore, my submission to your lordship, my lord, is
Roughly how much time?
not tomorrow. I will complete, probably in all probability. In all probability, tomorrow I will complete. I think, unless court doubted any doubt is there, I have not have to clarify.
Tomorrow, we'll resume tomorrow post lunch.
Yes, my lord.
Same time.
Yes. I stopped today. ಒಂದು ನಿಮಿಷ. Unfortunately, state has not filed its reply in this case.
You must be ready whenever they close. Whenever they close, you must immediately start reply. Don't ask for separate date. We are putting you on notice earlier because we have severe administrative difficulties because we are managing our individual rosters. So we are not going to give gap.
It is impossible, my lord.
Take up
And shortage of
thing continuously. So we are putting you on notice that once they conclude, immediately you must be in a position to start your.
a shortage of judges, very difficult, my lord. Very difficult.